Yeah,
good morning once again. I welcome my Lord Justices on the panel and in the audience. We have justices in the audience as well. Learned Senior Advocates of Nigeria on the panel and in the let me welcome you all to the webinar organized by the Nigerian Law Publications Limited, the publishers of Nigerian Weekly Law Reports and other law books. As we all know, the Nigerian Weekly Law Reports was founded in 1985 by late Chief Gani Fawemi of blessed memory, Senior Advocate of Nigeria, Grand Commander of the Order of the Niger. May the gentle soul of Chief Gani Fawemi continue to rest in perfect peace. In the 35 years of the existence of the law reports, it has grown to be the most consistent, the most authoritative, and the longest running consecutive law reports in Nigeria and indeed in Africa. And it has set the bar that it is actually possible for a weekly publication on a regular basis to be possible in Nigeria, in spite of the debilitating environmental problems that we have. The theme of today's webinar is technology and legal practice in Nigeria. And it is to mark the public presentation of the digital online version of the Nigerian Weekly Law Reports. And in line with recent developments in legal practice specifically and the new normal in professional operations generally, the broad objectives of this seminar center on the use and impact of technology in legal practice. The Nigerian Weekly Law Reports, as the flagship of law reporting in Nigeria, appreciate the enormity of the phenomenon and its relevance to legal practice, especially legal research. And we deem it necessary to organize this webinar to address the issue so as to bring it to the front burner for legal practitioners and researchers to adjust to and comply with the new developments and the new normal. To discuss the issue today, we are blessed and honored to have the leading lights on the bench and the bar. I call them the giants of profession, experts of repute, specialists, knowledge, and their experience on the different aspects and dimensions surrounding technology and legal practice. In fact, one of the justices called me and said, Ayo, how were you able to compile the list of this star-studded panel for today's webinar? So, my Lord, I have the pleasure to introduce my Lord, the Honorable Justice John Eyang Okoro, Justice of the Supreme Court of Nigeria, is our special guest today. Welcome, my Lord. I welcome my Lord, the Honorable Justice Ellen Moronkeji Ogunwumiju. She's on her way to us, the Presiding Justice, Court of Appeal, Benin Judicial Division. My Lord, the Honorable Justice.
I'm not on the way. I'm here already. I can see you, but it seems as if there's a glitch from your end, because I couldn't join as a keynote speaker. I had to resort to joining as an attendee. Can you hear me?
Yes, my Lord. Now we have you in the right place that you ought to be. You are welcome, my Lord. My Lord Justice Ellen.
Am I in the right place?
Yes. You are in the right place, my Lord.
Oh, okay. Okay.
Except that we are yet to see your face, my Lord.
Okay, let me change that. Okay. Okay. I have been grappling to. I have about 4 telephones, 3 these are the issues of technology. So please go on.
The Presiding Justice of the Court of Appeal, Benin Judicial Division. I have the pleasure to welcome Malam Yusuf Ali, Senior Advocate of Nigeria, a live bencher, member of the Legal Practitioners Disciplinary Committee of the Nigerian Bar Association, a giant at the bar. You are welcome, sir. Chief Emeka Ngige, Senior Advocate of Nigeria and the Chairman of the Council of Legal Education in Nigeria. I welcome you this morning to this panel. I also welcome Mr. Oluwakemi Pinero, who prefers to be simply called Kemi Pinero, Senior Advocate of Nigeria, and the Chairman of the Law Reform Commission, Lagos State. Last but not the least, we have in the panel today a young, vibrant, upcoming lawyer, Mr. Charles Ajiboye, the past chairman, Young Lawyers Forum, Ikeja branch of the NBA. We are all welcome, and there is no doubt that with the panel we have in place today, it's going to be an exciting experience for us. So I will call on my Lord, Justice John Iyan Okoro, to give us the opening speech and special guest. Before then, I will quickly run through an introduction of our Justice Okoro. My Lord Honorable Justice John Iyan Okoro is a judge with a vast experience, spanning over 35 years on the bench. He served on the bench of the High Court from 1998 to 2003, when he was elected to the Court of Appeal in recognition of his sterling hard work on the lower bench. And in November 2003, my Lord was elevated as a justice of the Supreme Court. In between his time in the High Court and the Court of Appeal, my Lord Justice Okoro also served in various election petition tribunals all over Nigeria. And presently at the Supreme Court, as most of us that read the law reports know, Justice Okoro has been responsible for shaping the opinions on diverse topics and issues affecting Nigerians. I have the honor and the pleasure to call on Honorable Justice John Iyan Okoro, Justice of the Supreme Court of Nigeria.
Thank you, Ayo. Let me express my profound gratitude to the promoters of the Nigerian Law Publications Limited, publishers of the Nigerian Weekly Law Report, the NWLR, for inviting me to participate in this webinar on an issue which the legal community in Nigeria and their counterparts all over the world are trying to make a new normal. May I also pay my tributes and respect to the late Chief Gani Fawehinmi SAN for his pioneering efforts, which birthed the Nigerian Law Report some 35 years ago. May his soul continue to rest in peace. I congratulate the organizers of this webinar for adding a digital version of the Nigerian Law Report to their numerous publications. The legal community in this country and worldwide cannot thank you enough. The theme for this discourse, technology and law practice in Nigeria, is not new. It has been with us for some time now, and as far back as July 2012, the National Judicial Council unveiled the Judicial Information Technology Policy, which is in the process of being activated and made to work as a new normal now. Over the years, the Supreme Court of Nigeria, some divisions of the Court of Appeal, the Federal High Court of the FCT, and some state high courts, prominent being the Lagos State High Court, have made frantic efforts to activate and actualize the policy. Had we made the policy a priority before now, we would not have been caught napping in the advent of the COVID-19 pandemic. That took the world by storm and is still raging. Indeed, the Nigerian legal community was largely unprepared, as other jurisdictions like the United States, the United Kingdom, including some African countries like Kenya, Ghana, which had invested heavily and integrated information technology into their justice delivery systems. Readily, they switched to using technology in conducting legal businesses. I must, however, commend the Nigerian courts, notably the High Court of Lagos State, the FCT, High Court, national endorsement, which issued practice directions that for the conduct of limited court businesses via online platforms such as the Zoom, Microsoft Teams, Skype, etc., notwithstanding reservations of its constitutionality by some stakeholders. So we're not really left behind. In fact, I have taken part in some virtual hearings of some motions in the Supreme Court during this lockdown. This is a commendable first step. During this COVID-19 pandemic, exactly on the 7th of May 2020, the National Judicial Council, in furtherance of its policy formulation mandate, issued what it termed guidelines for court sitting and related matters in the COVID-19 period. This is meant to guide heads of court in adopting or formulating rules, directives, and guidelines as appropriate to the legal and material circumstances of their courts with a view to achieving the goal of safety, delivering justice in these unprecedented times. The guidelines recommended inter alia, virtual or remote court sittings with the view to avoiding as much as possible sittings in the physical courtrooms, save as for time-bound, extremely urgent and essential matters that may not be heard virtually or remotely. Earlier, in 2016, to be precise, the Nigerian judiciary adopted a national judicial policy which provides for the use of ICT in clause 2.4.10 as follows. A, the judiciary in Nigeria, both at the federal and state levels, shall encourage the use of information and communication technology, and in particular, all courts shall, as far as practicable,
earlier this morning intimated us of the little problem he was having with his connectivity in Calabar. My Lord is talking from Calabar. He's back now. Thank you.
So, secondly, I think you are hearing me now.
Yes. For a few minutes, yes, my Lord. For a few minutes, you are off.
Yes, I was off.
Yeah.
Secondly, judicial bodies and institutions shall be equipped with information. Judicial officers shall undertake mandatory training on the use and application of information technology systems, including electronic and digital recording and transcription of court proceedings and processes. Based on the above policy, and even before the advent of COVID-19, some form of ICT was being deployed in Nigerian courts. For instance, the Evidence Act 2011 provides for the admissibility of computer-generated evidence, which was not there before. Some courts of record in this country have made rules of procedure containing provisions enabling electronic filing, like in the Supreme Court, electronic service of court processes, and even a limited form of virtual hearing. I remember that in February 2018, the Supreme Court of Nigeria, in order to give vent to the said technology policy, launched an electronic mailing system and gave an ultimatum of July 18, 2018 as the last date for filing physical court processes at the Supreme Court. This was to enable litigants and opposing parties to file and serve their processes online without necessarily visiting the Supreme Court physically. The project aims at easing communication system between the bar and the bench, reduce paperwork and incidental costs, and ultimately speed up the court process and thereby improve administration of justice. I, however, regret to say that most lawyers, as I speak, have not taken advantage of this provision. You still find lawyers traveling miles to Abuja to file processes at the registry of the Supreme Court. But I don't know what could be the problem. It has been suggested that the legal profession, being a conservative industry where decisions are made by referencing past cases and legislation, some of which are centuries old, many lawyers and judges have expressed reservations about moving from the traditional text-based approach to using technology to support their work. That notwithstanding,
Lord is reaching us from Uyo in Akwa Ibom State, and I think he still has a little problem. Maybe we should proceed, and then my Lord will join us again. I can see he's still here, except that we cannot see his face now. The lead speaker of today's, my Lord is back.
There must be a paradigm shift, I suggest, because today ICT is used in all nations of the world. Big corporations, even small firms all over the world have returned hooked to ITC. It is a generally accepted view that ICT has the capacity to improve efficiency, increase accessibility, and has the more general effect of promoting confidence in the justice system. We have no reason to lag behind. I counsel both the bar and the bench to bring justice to our people. In a developing country such as ours, the implementation of technology in the legal sphere, and particularly in remote or virtual hearing, comes with a lot of challenges, which may include poor infrastructure, which we are all aware, network disruptions like the one that we are passing through, even as I read this my address, and connectivity issues. Some people argue that hacking is part of the problems that we have in this system. Some argue that some indigent litigants may not be able to be part of the system. And those other people argue that illiterate, those who are illiterate, parties who are illiterate, may not be part and parcel of what we are doing. Well, there are some witnesses who could come to court, but they may not have the money to buy a computer or afford a connectivity to join such an issue. Well, one may argue that even if notice of cause list, access codes, links, or meeting IDs for a remote hearing are given to parties, even published in the website of the court to enable interested members of the public to observe court proceedings without any discrimination, the above challenges could render the whole exercise a mirage. As has been suggested elsewhere, we should not emphasize much on those challenges. Rather, our discussion should focus on how to surmount those identified challenges. Remote or virtual court proceedings are not intended to replace or supplant in-person hearing in a physical courtroom. It is merely complementary. It is not all matters, I think, that are suitable for virtual hearing. It is thus part of the case management function of the court to decide whether or not any matter should be virtual. Nothing good comes easy. The teething problems should not deter us. As advanced countries manage these challenges, we should follow suit. I need to emphasize that these challenges are not peculiar to Nigeria. In a recent matter in Australia, Capic and Ford Company of Australia, 2020 FCA 486, the Federal Court of Australia, Parem J, acknowledged that the use of technology in law practice, and particularly in remote or virtual hearing, could be plagued by such constraints as technological limitation, physical separation of legal teams, challenges in cross-examining expert and lay witnesses, virtual, document management, trial length, and expense, as well as future issues. Notwithstanding, the learned jurist insisted that, and I quote, "I think we must try to make this trial work. If it becomes unworkable, then it can be adjourned, but we must at least try." End of quote. We are aware that the number of persons infected by COVID-19 is increasing by the day. It is uncertain when the virus will come to an end. As observed elsewhere, postponing the administration of justice and restriction of court sittings to urgent matters only may not be in the interest of justice. Both the bar and the bench must collaborate and think out of the box and probably make sacrifices in making the use of technology in our justice administration and delivery a reality. We can use and manage the existing platforms to administer justice. Counsel does not need to travel from Lagos to Abuja, already filed and exchanged. It is a waste of resources for counsel to fly from Sokoto to the Supreme Court in Abuja, only to, quote, to move in terms of the motion papers. There is no reason why judges and justices must sit in court to read judgments, which can conveniently be published in the website of the court and copies sent to parties and their counsel via email. Parties who have filed and exchanged written addresses in support and or in opposition to any motion need not appear in a physical court, sitting in a court to adopt written addresses. In spite of all the perceived and real challenges, let us join our hands to put Nigeria on the world map of countries leveraging on technology to drive their legal system. I thank you for your kind attention.
Thank you very much, my Lord. That was Honorable Justice John Nyang Okoro, Justice, Supreme Court of Nigeria. My Lord has set the ball rolling and has set the tone for the discussions today. Thank you very much, my Lord. My Lord, I how we have been caught napping by the COVID-19 pandemic, and we are very happy that my Lord also took us to some other jurisdictions where they have been able to summon the initial problems caused by the pandemic, and now we can successfully use technology to continue to do business. Finally, my Lord enjoined the bar and the bench to collaborate in this noble venture to use technology and to make it a reality in Nigeria, and I'm sure we shall get there. Thank you again, my Lord Justice John Nyang Okoro. Somebody reminded me that I didn't introduce myself when I was introducing the panel. My name is Ayo Olanrewaju. I am the Deputy Editor-in-Chief, Nigerian Weekly Law Reports, and the Chairman of the Editorial Board. Thank you once again, my Lord Justice Okoro. Now we move on to our lead paper. Our lead paper, the lead speaker today is Justice Kashim Zana. Justice Kashim Zana is the Chief Judge of Borno State. is an internet guru known worldwide for his work in this area. But I'll quickly tell us a little bit about him before I present this paper. My Lord Justice Zana was appointed a judge of the High Court of Borno State in 1998. Zana is currently a member of the National Judicial Council and of his Performance Evaluation Committee, among others. My Lord sits on the boards of several international bodies in the field of law and justice, like the International Society for the Reform of Criminal Law, International Institute of Justice Excellence in The Hague, and is the Vice President of the Commonwealth Judicial Education Institute and Deputy President, International Organization for Judicial Training. My Lord was recently appointed into the advisory board of the United Nations Global Judicial Integrity Network, GJIN. My Lord is a regular speaker, presenter, and trainer at numerous national and international fora, and is regularly invited to expert group meetings of the United Nations Office on Drugs and Crime and the United Nations Development Program. Justice Zana is responsible for developing guidelines and programs for the work. Is a recipient of the Medal of the International Society for the Reform of Criminal Law in 2012, and the United States National Center for Courts Distinguished Service Award in 2013. Honorable Justice Zana is currently the chairman of the National Judicial Council, the Supreme Court. The Nigerian legal email has also been designed and rolled out for service of court processes and other communication in the judicial ecosystem. As an addendum to that, I can confirm that the first virtual court hearing in Nigeria was conducted in the High Court of Borno State. Don't ask me who was responsible for that. I present our lead speaker, Honorable Justice Kashim Zana. You are welcome, sir.
Thank you very much. My lords and distinguished members of the panel and distinguished attendees and guests, as you may have noticed, I've been in and out. Technology has its limitations too. So I'm a little bit unsettled and nervous that it may go off again. So permit me if I rush a little. But I must just update, let's say, my profile as read by Solar Rewaju, that I am no longer on the NJC and so not in the Performance Evaluation Committee too. But the Judicial Information Technology Policy Committee, I'm still heading because that one, I was actually appointed before I was made a member of the NJC by, at that time, Justice Mustafa, who said, well, anybody in the judiciary, even an accountant, I remember he said, from outside, the council can bring him for special skills to head a subcommittee of the council. What more of a judge who is even eligible to be a member of the council? So it was subsequently I joined the council. So this is an update on the CV. I'm sure I will not be even surprised if I'm the one who forwarded this same CV to Olarewaju. So I'm not blaming him at all. It's just that sometimes, again, technology, you just see short bio, long version, short version, click, send, and then you go and face other things. So that may have accounted for it. So that's it. Another issue I want to clear before lest I forget is, clearly it's technology we're talking about, and there is going to be a webinar on the legal mail that His Lordship even now referred to in his speech, the one that is meant to be the backbone for the e-filing for actually all high courts in Nigeria, Court of Appeal and the Supreme Court, communication, service of processes, communication with lawyers, between lawyers. So, and it has been having challenges because some lawyers couldn't obtain the mail for certain reasons. Some obtained but couldn't use it. So many. So fortunately, now this is an opportunity to address a larger audience. Actually, these are just small issues of showing how to go ahead and get it, how to use it, and etc. So there will be a series of webinars on that, and I advise that all lawyers and court staff too particularly those in the registry, because they too will be receiving these mails to attend this webinar. I've already forwarded the link to Mr. Rewaju, so he can get it posted on the chat so that attendees can now click on it and register. All your technology-related questions actually will be taken in the course of those webinars, even those unrelated to the issue of the legal mail, because it is the same committee that is working on this thing. So you're free to ask today too if we have time, but you will also have time completely devoted to that one. Everything has been completed. We have something that already is being copied, like he said, in many places. Namibia is on my neck that we have assisted even Caribbean countries. Why can't we assist African countries? But we do intend to assist them. It's just COVID that intervened. So it's not something that is theoretical. It's something that has been proved. Trinidad is already celebrating using it. They came here, met the Vice President, met Justice Mahmoud, who permitted us, and then we actually formed a consortium to help whatever African country that needs help in that process. So please join that webinar. Please make sure that that link is, the invitation is posted on the chat. This is so that lawyers who are now participating may click on it and then join the webinar. And I'm glad that we have up to 300 and something right now already. I mean, you can't beat the rich. When it is Nigeria Weekly Law Report, I think you can't beat the rich. So that is a good opportunity. Now, SARS, I know it's going to be very difficult staying in a webinar for long. I was invited to speak. Actually, initially it was going to be a live event in Lagos, and I was looking forward to going to ECO. But unfortunately, COVID came in, and then after resisting for some time, hoping it would go away, apparently they decided that, look, we better get this thing out of the way. So I was told that we'll do it now online, which I welcome to. But to be honest with you, that subject I've already covered almost exactly 2 years ago. That was 21st day of July, 2018, when the Nigerian Law School class of 1978 invited me as the guest speaker at that time. And I gave a lecture. They gave me the title, and I didn't change it. I talked exactly as they wanted in the title, because that class, if you know, that's a very heavy class. You can't change anything they give you. Almost half of the Supreme Court is members of that class, the class of 1978. They call it the golden class, and I can't dispute that. So I gave this lecture. I wanted to earlier on display it on this, but I'll just lift it up for you to see. And I'm going to through that lecture with updates, because this is 2 years old. But I've also sent a copy. I'm sure all the panelists already have gotten the copy and read it, and I will have no objection. And I'll prefer lawyers in attendance also to have the soft copy and read it. It will be much more useful than what I'm going to tell you now, because there are links to almost all the sources I've consulted, and that will prove beneficial. And that now gives me an opportunity to just quickly go through what's in that lecture and highlight some of the developments since 2012. This is technology. Now, to be honest with you, the question of technology now, when it relates to legal practice, the talk is not about reforming practice or improving practice, no. The consensus is going to transform practice to an extent that if someone had gone to sleep a few years back and wakes up in the next 5 years, he will not even recognize what is being practiced. It will be transformed, it will be changed in all manners of speaking. That is actually the consensus. I've not met anybody, or I've not consulted any source that says otherwise. If there is any dispute or any conversation, it is around how far the transformation, is it going to end completely, or is it going to be technology used by lawyers, or is it going to be lawyers used by technology? All this, actually, when you go into the lecture, you see that they really make sense. Sometimes, like one of the disruptive technologies is a situation where you have the company has only 10 and only one is a lawyer, the others are engineers, and what is really rendering is legal service. So what do you call that? Is it not technology using lawyers, or is it lawyers using technology? It's to that extent, and I'm talking about what is happening now. At the end of it, remind me if I forget. If there is time, I will just play some clip. And very interesting, it's a comedy actually, so that depending on how the audience likes it and the organizers like it, you either stop it at any time or you allow it to run its course, so that it will not count within the time that is allotted to me. But I'll leave some 2-3 minutes, hopefully. Now, in the year 2016, I was quoting one Maher who predicted that the technology at that time that lawyers were using and enjoying because of the productivity will soon unbind itself, escape their control, and transform legal practice. I never realized how soon that may be until I was given the paper, the lecture to write that time. But let me quickly now go through the contents of that lecture and just highlight some of the technologies, or rather the advances in technology that are seen as the real threats, threats, if you will, to legal practice, or rather the enhancers of legal practice, if you want to take it as a positive. There are quite a few, but all of them, of course, stem from, I'm trying to get, let me see if I can. Sorry. So all of them are technologies based on, of course, information technology, because law is about information. How to store information, gather information, disseminate it, use it. So it's not surprising, therefore, that information technology the transformation in information technology will transform law and its practice. Now, okay. Good. These are the 5 key developments that are expected to impact technology and are already impact the practice of law, and are already impacting it. Big data, cloud computing, legal analytics, AI, artificial intelligence, and blockchain. Now, big data, in short, refers to the enormity of the data that is now available. Unthinkable, exponential. It is said that the data being generated, and that is data is information about almost everything being generated in this world, in the next 6 years will be doubling. The amount of information available will be doubling every 12 hours. Incredible. Now, what is the implication of this? How do you use it? So many things. Predicting behavior, predicting trends, knowing what's going on. Numerous, but remember, data is information. Now, hitherto, even if you have this data, you have to be a big company with lots of resources and computing power to be able to use it. But then came cloud computing, which made big computing power available to almost even a small firm. You don't have to buy your own hardware. You don't have to invest in backups. You don't have to invest in all these big investments. All you need is just what you need. And that you can get by accessing it through the cloud providers who now make this investment, and you pay your own subscription or pay as you need. And then a vast computation power is available to you. That will prove very, very transformative to the practice of law. because what was hitherto impossible and not economic became now possible and doable. Then legal analytics, again, needless to say, it's obvious. All this data that is now available can be analyzed, and generally it is analytics, and when it applies to law, it's called legal analytics. Now, there are software that can predict the judgment of a judge by analyzing his behavior and judgments over the years, predicting trends in the law, so many things. And the advanced analytics that are enabled are because of, now let's go back, big data. The data is now available, even if it is in your chat platform in WhatsApp, Facebook post, speech that you delivered at the inauguration of Nigeria Weekly Law Reports online. All these are now data that are potentially stored somewhere. And these would be analyzed along with so many other things. And the power to do that is allowed by cloud computing. Even a firm, an individual can do it, deploying these analytics softwares. But to even do that more efficiently and effectively is artificial intelligence. Now, another development in technology that has impacted and is going to impact and transform the practice of law. Well, I think we all have ideas of what artificial intelligence means, but it's much more than that. It's the intelligence processed by the computer, but actually not in the sense of the reasoning that a human being uses. It is, you may call it machine learning or reinforced learning. The computing power, the AI has its way of reasoning, if you will, because in the end, it is the result that matters. It will achieve the result, not exactly the way the human being works, but just by looking at patterns and so many other things. In fact, some, it is said, are still not known. You just see the result working, but you wonder how it did, and that's what scares a few people. Now, then blockchain technology. That also has a lot of impact. You may have heard, the one that easily gives lawyers the nightmares and maybe judges is that there will be smart contracts that will not require even courts to enforce and all this. All blockchain technology means is the benefit of it particularly is the immutability. It's something that information stored there cannot be changed without being detected. And that is because of what is known as the distributed ledger. Just to give a simple example, it's like in those days of NEPA, they kept ledger. And if your bill is so high, some unscrupulous person can go and have the ledger removed so that there will be no record of his bill. And then maybe they get something and it continues like that. So what if now this ledger exists on 200,000 computers? Even if you remove from one, the others will still be there. Not that they can read. The technology is such that what you know is that it has been tampered with. And so that makes it what is called immutable, because you have to go around all and change it. And even then, it will be time stamping the changes you have made. So these are factors that have come to impact the practice of law. Now, apart from technology, there are two others. External to technology, but probably linked to technology. That is liberalization and cost of legal services. Now, in the Western world, where everything has, you need legal services for almost everything, there was this complaint about the cost, even the companies, let alone the small businesses and individuals. Now, in England, the Legal Services Act of 2007 that came about because of the report of Sir Clementi, an accountant who was given the task of looking at the restrictive nature of the practice of law, recommended liberalization. That came because of pressure. The public, the society just thought it was, the cost had to come down. And now that allowed law practice to be owned by anybody, by companies. Even a supermarket can now have a law practice and render legal services. Accounting firms have now moved in, and now that is where the danger also comes. They came in with a lot of money and can now leverage technology on a wider scale and offer legal services in a cost-effective manner in such a way that they will now undercut the traditional practitioners of the law. They are called the alternative business structures. Already, they have been licensed. In 2011, it started. The big law firms, accounting firms, KPMG, PricewaterhouseCoopers, Ernst & Young, all now have legal listing. I am sure as lawyers in the audience, some here in Nigeria know that some attempts have even been made here, and I don't know where it ended, but it's not going to go away. So these have now combined the complaint about cost of legal services, the liberalization, and then these technologies have combined to have and portend tremendous impact on the practice of law in Nigeria and anywhere else, because Nigeria cannot be immune to what obtains elsewhere. So, now, what are these disruptive applications that I'm talking about? Quickly, document automation. You see that the legal drafting that we learned is still useful, but there are software that can do a lot of that now and better. They give clean drafts where you just need to alter a few things and then you are done. There are also what are called alternative legal service providers. All these were enabled by these technologies that are listed. For example, LegalZoom, Avo, a legal Rocket Lawyer, all these things. What they do, simply, you go in to their site for a small fee. You just type in what you want. I want this thing. My problem is this thing. Okay, it will be asking you questions and you'll be answering. And then lo and behold, you have a legal document in your hands. Or you can even draft a will through that. Or even text a lawyer. That one, for $20, you just send a text and you get a legal advice for $20. For follow-up questions, $8. And you're done. Another one, the big ones, virtual law firms. We now have law firms enabled by these technologies, particularly cloud computing that I earlier referred to, that exist completely on the cloud, on computers. They don't have any office, brick and mortar, anywhere. And we're not talking about small practices. The last time I checked, Cool Hand Meadows, one of the big ones in the US, was already doing routinely $100 million deals and takeovers and mergers, acquisitions, name them, big money. And then there's this practice that is called gigging. Lawyers who just refuse to even have any office whatsoever and not to join any online law firm, but are freelance lawyers, so to speak. And they are there for hire because there are now softwares that have come up to render services of connecting them with those who need them. So it's called gig practice. Maybe even a big law firm may require extra hands because of a big project. You know the projects over there. So they just go in on site, do the job and go with their computers or work from home and do it. These are all new practices that are going to become commonplace. Label question answering, very interesting one. It's not a matter of typing in keywords. No. Artificial intelligence has now enabled a situation where you can ask the software questions like you would ask Emeka Ngige SAN in the same language you ask the learned senior advocate. It's the same way you ask that app and it will give you an answer. It will not only give you an answer, it will go through billions, and I mean billions of documents within a second and give you a list of possibilities and give you its confidence in the answers that it has. Like the one that you have now on the screen, a sample question. Can an automatic stay be lifted on the request of a plaintiff in another case? Something like that. These are just legal questions. And then you will see billions, laws, law reports, acts, whatever. All these big data that exist within seconds, you have the answer. It was developed by one Aruda, who is the CEO now. You will find this one. And then you'll be surprised. Who else? Obiagele Jimo Yeah, that name as a Nigerian, it's not strange to you. So if you think this is something that exists elsewhere far away, it's the Obiagelegimos that are now doing this cutting edge. Actually, this leverage on the IBM's Watson to do it. Please just read the lecture and you'll see lots of details on that. Time is really, really, really running out. And I'm sure the organizers will be uncomfortable with the speed I'm going. So chatbots too. This is another lawyer. He was just tired of paying parking tickets. And he became old enough to leave home. And now his parents said, you're going to pay on your own. He didn't think it was justified. So he formed this application, Do Not Call, Do Not Pay, whereby he built in the rules of parking, what you can plead against or defenses against wrong parking or not parking properly or not parking at the right place. There are rules. So he just fed these rules into the computer in such a way that he came up with this app called Do Not Pay, whereby you just go, my complaint is I was given a wrong ticket. It's not fair. Then it will be asking you a question, where were you parked? How far was it from a parking lot? How big was the parking lot? Was there a mall around it? All these are laws that will exempt you from punishment or from paying if you park this thing. And then it will just print out clean, neat document that you can go and file with your pleadings and everything, as we call it. And he, as at the last time I checked, even 2 years ago, had helped 375,000 people to avoid paying for the tickets. Is the clip out at the end of it. Then legal crowdsourcing, whereby it's on the on the cloud. People just contribute, lawyers and non-lawyers and all this, and they answer questions, and through that you can get good legal advice. Now, honestly, I don't want to stretch the time. I was given 20 minutes, and already the 20 minutes are over. But my take is this. In the paper, you'll find the debate. In the lecture, you'll find the debate as to whether these systems will ever replace lawyers or not. Well, my own take, I've given both sides. My own take is that it cannot replace lawyers. However, to survive in legal practice will require much more than what it takes to survive now. It will take ability, stability, affinity, agility. Ability, forget it if you don't have technology. Ability means technology and the ability to use it. Stability can only come where you can survive the rocking of the waves. And that too, you need technology. Affinity is, you have to like affinity, in short. You have to like the job, like the technology, like what it takes, and then be agile to react to new developments, change, adopt, and all these things. I've already told you that I've not come across anybody, any source that says technology, law practice will not be transformed by technology. I've already given you that from the beginning. Now, I will try and get you to the clip and actually leave time for questions and answers. I think that is, okay, let me just stop this show. But would you want me to play the clip, Mr. Olari Owaju?
Yes, my lord. I can give my lord a few minutes to do that, sir.
Yeah, because I am very conscious of not causing a disruption in the schedule. Or do we leave it until the other presenters? Maybe
my Lord Justice Okoro can deal with the
application for extension of time.
Yes, he's asking for extension of time. And my Lord Justice of the Supreme Court is the only one competent on this forum now to grant such.
We can grant him 5 more minutes.
5 more minutes?
Yes.
as my lordship pleases.
Okay.
My lord, I was not heard in opposition.
You were not heard?
In opposition.
Ah.
Lanesi, my lord did not see your counter affidavit.
You slept over your right.
I'm learning practice of law now in the technology age.
Actually, the Lord's application was expected. So, Kemi, you cannot be heard.
Okay, what we'll do is this. Go ahead. Let the next presenter come in. In questions and answers, I'll just slot in this clip just for the entertainment value of it. I think I'm done. So, for you to practice law, things are going to change, and you need to be agile and all the next stuff. Thank you very much, my lords.
Thank you.
Thank you very much, my Lord, Honorable Justice Kashim Zana. We have a lot that we'll have taken away from your lecture today. You have actually shared your worldwide experience with us on the use of technology and the fact that that is the inevitable route for legal practice. My Lord referred to the paper he delivered in 2018. Some people have been asking us on the screen. We have the paper and we are going to post the soft copy of the paper on the website of the Nigerian Law Publications so that anybody can go there and access and have a copy. You need to see the paper to know that my Lord has just touched like 5% of what is there. Every single legal practitioner in Nigeria who wants to look to the future must read that paper by Honorable Justice Zana. We'll put it on the website and for everybody to have access. My Lord asked the question that everybody would love to know, whether what we are going to have is that technology will totally replace lawyers. But he concluded, I'm sure to the joy of so many lawyers, that as advanced as technology is, you can rest assured that it cannot completely replace us. But with a caveat, my lordship put a caveat. Every lawyer has to raise his game in the technology environment, be able to be functional. Before I call on my Lord Honorable Justice Moron Keji, we have seen from our side here that we have some personalities and some of my lords in our audience. I would simply quickly want to recognize some of them, sir. We have attended this seminar, my Lord Honorable Justice Olatunde, Honorable Justice Olubumi Oyewole from the Court of Appeal, Enugu Judicial Division. We have my Lord Honorable Justice Obande Oguanya, who sits at the Court of Appeal, Lagos Judicial Division. Justice Adeboye Bolagunte of the High Court of Oyo State is here with us. And that is actually the beauty of technology. We have people from all over the world, Canada, UK, Australia. Somebody has posted in from Dubai watching this seminar. I doubt whether if we had the physical launch of the program, we can have such audiences. Chris Uche, Chief Chris Uche, SAN, is here with us. Senior Advocate of Nigeria, Chief Chris Uche, yeah. Welcome, sir. Mr. Joe Kari Gazama, Senior Advocate of Nigeria, is in the audience with us here. Mr. Kola Olawoye, Senior Advocate of Nigeria, is here. Mr. Kehinde Eleja, Senior Advocate of Nigeria. Mr. Nasir Abdul Dangiri, Senior Advocate of Nigeria, who are here from all the nooks and crannies of Nigeria and the globe. Mr. Nasiru Tijani, the Director General of the Nigerian Law School, Lagos, is also in the audience. I will recognize more people as we see them. Thank you once again, Justice Zana, for your paper. The next speaker to deliver the paper is my Lord Honorable Justice Eileen Moronkeji Ogunwumiju. My Lord is the presiding justice, Court of Appeal, Benin. Honorable Justice Eileen Moronkeji Ogunwumiju practiced extensively and successfully for almost 20 years before she succumbed to the allure of the bench when he became a High Court judge in 1998. Soon after, our industry, which we all know, and her acumen was quickly recognized, and she was elevated to the Court of Appeal in 2005, where she has served in several judicial divisions of that court. Justice Ogunwumiju is presently the presiding Justice, Court of Appeal, Benin Division. My Lord has become renowned for her notable pronouncements on the appeal bench in so many areas of the law. My Lord is a member of the panel chaired by Justice Zana, Judicial Information Technology Committee, and she is also the chairman of the ICT Committee of the Court of Appeal. My Lord Justice Ogunwumiju, PCA, you are welcome again, and we are ready to listen to you, my Lord. For 10 minutes, I know you have more.
I didn't mention that my Lord is of 1978 set.
I would have said so myself. My Lord, Honorable Justice Okoro, JSC, my Lord Justice Zana CJ, other panelists, it gives me great pleasure to be here. I feel highly honored to participate in this webinar to discuss technology and law practice in Nigeria, organized by the Nigerian Weekly Law Report. I also want to recognize the fact that Justice Ariowola is watching us of the Supreme Court. He has contacted me to say he's looking forward to my presentation. I don't know whether that was made to feel me nervous or emboldened. So I think when I finish, we'll know what type of encouragement he gave me. My Lord Justice Ariowola is also recognize his presence at this webinar. Well, my brother and my chairman at JIPCO, the Judicial Information Policy Committee of the NJC, my Lord Justice Zana CJ, has said it all. And my Lord Justice Okoro too, they've said most of what I intended to say. And my Lord Justice Zana has spent the last 10 years, almost the last 10 years of his life, on this ICT project for the NJC. And he is very passionate about the improvement of justice delivery through the use of technological tools. Like I said, I'm tempted to say that I rest my case on all that both of them have said, but I'll say a word or two about how technology is impacting the judiciary, which is essentially the downstream sector of the legal practice in Nigeria. And I will speak to how technology has and can bring improvements in justice delivery and positively impact legal practice. So we're here basically to discuss legal-centric information technology, which means the use of technology and software to provide legal services. I would like to take a linear approach from personal experience to show how, for me, technology has shaped the practice of law. We had the first stage, the first stage of word processors. I'm sure most of us, when the computer came and we had to use laptops, we had this love-hate, love affair with our processor. When we type a few things and everything would disappear and all that. Many of us who are old hands here would remember Word 2003, Microsoft Word 2003. But these days, most of us have gotten the hang of it, and our PAs and secretaries, they deal with the sorting out of the whole Microsoft Word thing. This next stage is document management. Hot on the heels of that revolution of having a computer, a word processor, was document management. Sorting, storing, indexing, curating, and even the disposal of those MS Word documents become very important. For me, like an old wig like myself, I told you I belong to the 78 set. I carry along so many flash sticks up and down. to the annoyance of people around me. But the bustling new lawyer in practice needs a bespoke electronic document management solution with advanced indexing, storage, security protocols, and the like. They are now essentials. You cannot have a viable practice without these essentials. Then the next stage is the case management systems, the judicial case management systems, or as the hip crowd will call it, the JCM systems. We have all sorts of functionalities now that can be defined in 4 broad features. Electronic case filing. Backlog of unprocessed cases are a major challenge for court systems with limited resources. With the online data entry capacities of a JCM, for example, users can enter new case records and also update and save existing record in a fully searchable database. Moreover, lawyers can file case documents electronically, reducing the burden of paperwork on the court system, and in opening cases and ensuring that all documents are completed and filed correctly. Senior officials in the registry of all the courts can view an audit trail indicating when a case file was modified and by whom. Then the next stage is the case workload management. The processes and workflows of a court are unique to each individual court. Court administrators can set up filing, processing, approvals, appeals, reproduction, and editing of case documents based on court regulations and protocols. This feature expedites case processes by helping to define stages, roles, and permissions associated with case management. Document templates enable court staff to easily create and edit warrants, affidavits, orders, and decisions. Most of the High Court and Court of Appeal schedules, they have templates of processes that are there. They are abundant for use. They can be inputted into the system and just whipped out and used at will by court staff. And then, the issue of cost scheduling. An important aspect, I'm concentrating more on my own field, how this thing impacts, because we have a symbiotic relationship, both the bar and the bench. An important aspect of any case management system is managing case loads, scheduling and measuring the time between case filing and disposition. Most JCMs allow court officials to schedule hearings, arrange tasks, notifications, and set meetings for themselves or other court staff. In case scheduling, if case scheduling is properly managed, with case analysis and reporting, it will drastically reduce the public odium against judges. And I'm happy there are very senior judges on this webinar. Unless we are deceiving ourselves and think that and put our heads in the sand, that's why we think that there is actually no public odium. Most people who approach the justice delivery system in Nigeria, 90% of people have a very difficult time. A very difficult time. So all efforts must be geared. It is not just to come and attend the webinars and speak big language. I believe in the practical solutions. What are we going to do to make life easier? We are service providers. We are service providers in justice delivery. That's all we are. Whatever cadre of judges or court staff, we are service providers. Gone are the days when judges and lawyers were involved in the grand conspiracy to ensure that the lawyer milks as much as possible from the proverbial cow to the detriment of the litigant before resolving cases. There is software developed now that can trace the history of each case. After all, the justice system is in business of providing a social service, as I said. We must be accountable to the people we serve. Any litigant should be able to call a court to inquire of the status of a case with a few naira credit balance in his phone or her phone. The last dates of adjournment, at whose instance the adjournment occurred, etc., the motions granted, and the next date of adjournment should be a phone call away from any litigant or any lawyer. Then the issue of case analytics and reporting. tracking court performance helps to bring accountability, increases public trust and confidence in the judicial system, and enhances the rule of law. Modern JCMs should allow for if we develop our own, as Justice Zana had the foresight to develop some case management system for Nigeria. That is what Justice Zana was able to do. I'm sure he's going to tell us more about this during the question and answer session. He will expand on his quarterbacking of a case management system for the federal judiciary at the NJC. My Lord, that is already a question for you, my Lord Justice Zana, so that you can answer and explain to the audience at large. Then the issue of court recording, the next operational frontier to be captured, is the importance of having an accurate, complete, and accessible court record. These are things that are essential. If the court system does not work optimally, no viable legal practice can succeed. The next operational frontier to be captured is the importance of having an accurate, complete, and accessible court record. The official record provides a fundamental building block for the case, and makes the judicial system accountable, and makes appellate review meaningful. An accurate, fully reviewable record builds respect and legitimacy for the court system, promotes accountability, etc., and enhances the court's effectiveness. At the core of this is something that we have ignored, is the existence. We must have verbatim court record that will support the due process of law, and ultimately assist the assurance of justice in our system. In spite of the importance of court record, there are different kinds of court records in use currently. All of them analog, of course, all over the country. But all over the world, people are, getting into all forms of ways of having court records in such a way that the court recording is effective and cost effective, both cost effective and reduce and efficiency enhancing. These different methods of court recording, they range from the top bleeding edge speech-to-text engines with automated transcripts and video to the lower end of the spectrum of handwritten notes by judges and court clerks. Looking at both the conceptual and legal reasons for a record, the use of digital recording technology can serve as a critical solution to the issue of accessibility of court record. You are a justice of the court of appeal. There's a motion that, we are not able to appeal in time because we don't get access to the record of the trial court. And then they are coming with one motion or the other for extension of time. That takes care of that. If records are credible and easily accessible. We must, like the lawyers and the court system, the legal system, we must, like the automobile industry, phase out outdated means of doing things. That's just the truth. This means understanding that the inherent honor and nobility of the juries doesn't necessarily translate in being a reliable and efficient data-taking entity. When you are busy engrossed in writing, sometimes it's actually shameful to say that we are still recording proceedings manually in Nigeria. Then we have the another stage, that is the case management stage. The next rung of the ladder is the law practice management software, that is the LPMS. These software systems supposedly streamline case matter management for the lawyers, calendaring, client contact management, legal research, billing, invoicing, process management, with court case-based management systems. My esteemed brother and colleague, Justice Dana, my chair, he may decide to expound at length on the federal judiciary's efforts to automate the workflow of court processes. But of all the elements in the LPMS, the far greater contribution to the modernization of our profession, both of the the side of the bar and the bench is legal research, which NWLR stands for. Legal research is essentially the process of finding an answer to a legal question or checking for legal precedent that can be cited in a brief or a trial. Virtually every lawsuit, every appeal, every criminal, whatever, engages some amount of legal research. Our journeys have been long and touching big tome on thoughts to law pavilion, to Nigerian Weekly Law Reports, stacked with a full shelves full of Nigerian Weekly Law Reports, and now Law Pavilion, and now the electronic version of the Nigerian Weekly Law Reports, and the Squadron. It is at this juncture that a critical metamorphosis in our profession has developed: artificial intelligence. My brother has spoken a lot about artificial intelligence, and I won't go too much into that. Imagine a world where the jurist and the lawyer didn't just search for authorities, but by AI-driven analysis, a lawyer can know what will I say when I get to Justice Ogunwumijo and she will fall for it. What kind of language will I use to propound my case and or write in my brief that will appeal to the sensibilities of Justice Supreme Court. All these things are not no longer in the realms of fantasy. They are here and now. Litigation analytics are now used to anticipate judges' behavior, language they use, what to give you an edge before a judge. Complex computer intelligence based on court dockets are designed to enable attorneys to better plan and strategize around litigation, offering insights into motion and case outcome, judges, timing, opponents, and related subjects. I am sure that Nigerian lawyers, like lawyers all over the world, will soon jettison the old horse and buggy way of doing things. Litigants want their matters resolved expeditiously for good or for ill. I'm sure you recollect the case, the issue in 2016, when students at Oxford, Sheffield, I think, University College, Success Intelligence software that predicted up to 80% accuracy the outcome of human rights cases by analyzing previous court judgments. Of course, we've all agreed, Justice Okoro has agreed, Justice Dana has agreed, and I too concur with them that the robotic judge or the robotic lawyer cannot replace real-life judges and real-life lawyers. However, cannot be denied that AI and other forms of technology will only encroach further on the legal profession. Technology is accelerating the transformation of legal practice from a sole source, homogeneous, traditional, pedigree-centric way of doing things. The legal industry is getting diverse, and the global marketplace in legal practice is asking for expertise in various fields and in the business of delivering legal services. So, because technology is reshaping things. Let me just, I'll round up now. I'll just pitch in a word. Let me speak briefly on the issue of virtual courts, which has agitated quite a lot of people in the profession in the wake of COVID-19. I'm not wading into the current legality of whether it is constitutional or not. It's sub judice. But what I would like to say, my penny's worth, is that virtual hearing will be ideal to deal with only paper-based matters in court. Cases brought by way of originating summons, the numerous motions filed because of the civil litigation or appeals, etc. I cannot see, speaking for myself right now, I cannot see how a virtual full trial in a complicated civil or criminal case with the judge being bound to consider the demeanor of witnesses and determine on the spot the admissibility of documents aids the cause of justice. Right now, I can't see it. I remain to be persuaded. The appellate courts can make it work since they don't see witnesses. We all know that in Nigeria today, the Nigerian Weekly Law Report, which held sway for over 30 years, is no more the local champion of legal research. That's the truth. I don't know how to do this political talk. You are no more the leaders in legal research, because nobody wants to. There are others who have made huge technological impact in that area. I congratulate the law publications for trying to marry the old with the new. And I'm sure that the spirit of Chief Gani Fáyẹ̀hìnmí will bless you for this gigantic attempt. I hope you catch up quickly. Hard copies of law reports carried about in big bags to intimidate opposing counsel is just no longer the norm or the form. On a parting note, both bench and bar must grab and embrace technology. Not doing so is no longer an option. Thanks very much for taking the time to listen to me. I hope I didn't exceed my time limit.
Yes, my Lord.
I hope I didn't exceed my time limit.
We would have minded, my Lord, if my
I tried.
And I'm sure all of us, we enjoyed your energetic presentation.
Thank you.
It shows the passion with which my Lordship have for this topic and for the information technology. That was a very incisive paper. We thank my Lord, Honorable Justice Helen Moronkeji Ogunwumiju, Presiding Justice, Court of Appeal, Benin. Well, your Lordship in your paper sounded a note of warning to both the bar and the bench on the need to embrace technology, especially as it deals with court processes, the filing, the case management system. But my Lord took a very strong approach on the issue of virtual court hearing. My Lord concluded that virtual court hearing cannot be because of justice, especially at the trial courts. But that well, at the appellate court, it can be all right. I'm sure Mr. Oluwakemi Pinero was listening attentively to that. He's a strong advocate for virtual hearing in all proceedings. Well,
yes, I was.
We also noted that you took a dig at the Nigerian UK law report. Yes, and I must thank my Lord for being very honest and practical. And my Lord, you have appeared several times in our in-house seminars at the Nigerian UK law reports. And I remember that about 8 years ago, you were standing no warning to the Nigerian UK law report that we need to up our game. Well, we are the leaders. We are still the leaders in the legal research, and that's why we are online now. We may not be the first to come online in Nigeria, but I can assure you, my Lord, we have the resources to quickly catch up, and then for the good and betterment of both the bench and the bar, and for all the legal practitioners in Nigeria. Thank you very much again, my Lord. While my Lord was delivering our paper, we noted that, first of all, I want to welcome my Lord Honorable Justice Olukayode Ariwola, Justice, Supreme Court of Nigeria. He's been listening attentively to us. Professor Abubu is in attendance for the Director General Nigerian Institute of Advanced Legal Studies in Lagos. We have Honorable Justice Kudirat Joseph from the High Court of Lagos State. You are welcome, my Lord. Mr. Wale Adesokon, Senior Advocate of Nigeria, is here with us. Mr. Kamaldeen Ajibade, Senior Advocate of Nigeria, former Attorney General and Commissioner for Justice, Kwara State. Mr. Adekola Olawoye, SAN, is here, and Mr. Olatunde Busari, Senior Advocate of Nigeria. Thank you very much. Next presentation is from somebody that we all know, amiable and humble, a proper giant of the bar. He's a man that is known for his demonstrable humility, his reputation as the bar as an honest, open, and dependable professional is very huge. Malam Yusuf Ali is a fierce and highly effective and experienced litigator of the finest tradition at the bar, an expert in election petitions, and Malam Yusuf Ali is a fellow of the Chartered Institute of Arbitrators, UK, He's a fellow of the Federal Institute of Taxation of Nigeria. He's also a fellow of the Society for Peace Studies and Practice and Dispute Resolution Institute. Malam Yusuf Ali is the pioneer chairman of the section on legal practice of the Nigerian Bar Association, and currently is also a member of the Legal Practitioners Disciplinary Committee of the Nigerian Bar Association. I doubt whether there is anywhere you can mention his name in Nigeria and people will ask you who he is. I'm happy to call on Malam Yusuf Ali, Senior Advocate of Nigeria, sir.
Good morning, my lords, both on the panel and participants. Good morning, my colleagues with whom I'm sharing this platform. I also say good morning to the moderator who has been very effective in moderating what is going on here, Mr. Yolanrewaju. I must thank the Nigerian Law Report for this initiative, coming as it were when it is most needed. In the academia, the cliche is publish or perish. But I think in legal practice today is the IC compliant or you are finished. And I think that this will have come at a better time. So I thank you for the privilege to share the same platform with the legal giants and heads that have spoken before. And like Justice Ogunwumiju, may I crave the indulgence of all of you to adopt as mine the very able presentations of my Lord Honorable Justice Okoro, GSC, Honorable Justice Kashim Zanna, CJ, and Honorable Justice Eli Moronkeji, Ogumeju, JCA. I adopt all they've said as mine. I just have some short snippets to complement the very able presentations made by the other panelists. And I must say that in the true spirit of a lockdown, that's why I'm appearing the way I am appearing, because there is no physical work to do in the real sense of going to court. So I salute those of you that kept suits in your closets, in the offices that we put on for this event. Me, this is the way I came from my house. By way of introduction, I made the point, as we all know, that legal practice did not start when technology so technology came, and the law has been making a catch-up game there. And of course, when you technology to the use of law, in terms of application of technology software, such, I will make attention to a few of those applicable things as ably set out by Justice Zanna when he was making his presentation. Well, I'll quickly go to the subtopic, the growth of technology in law. Like I said before, law started long time before technology came in. And when some of us joined the legal practice, the things that were used to support legal practice, the typewriter, the old Olympia, and then of course you have carbon paper with cyclostyling machine. Those were the things that we met. And of course, there came the dictaphone at a point. You wanted to dictate something to your secretary, there was no more need to sit together. With the use of dictaphone, you can make dictations to your secretary. And then the UB such the revolution of all revolutions, the World Wide Web, which makes everything we've been saying to happen. No matter all the points made by Judge Zana were made possible because of the World Wide Web. The arrival of that changed the face of the world, not even legal practice alone. It changed the face of all professions. This technology, engineering, everything became changed. Accountancy, all became changed because of the World Wide Web. Of course, then you have the things like Google Suite, Microsoft, to meet you reference. And then the development before clouding came, you now had backup systems in different forms. When you save something on your computer, especially before laptop came, when it was just the PCs, you now had a backup thing, you back up your work so that in case virus attack your computer, you have something to fall back on, which form the basis of paperless office work. Then, law practice management in different forms for keeping time, for billing, and also became as not only accountants need accounting software, lawyers also need it for purposes of billing, especially hourly billing mode, and the management of. Then legal research tools about research, but I think you are also coming up now with your search engines. Now the legal research tools, you now have the Law Pavilion, Legapedia, Law, Law Digest, all these online search facilities, which has also changed the face of legal practice. It's now very common. You are in court. Somebody is taking an objection against you. If you have the Law Pavilion or any of these search engines, you just take your iPad or your handset, if it's a need, to search for relevant legal authorities to either counter or to support whatever position you are taking. Of course, the issue of cloud computing, which is the big thing that is happening now. Because, for example, the best goal is cloud computing, where every file you have, for purposes of easy retrieval and other documents can ever get lost. If something crashes from your own hand, you can always go back to the cloud to retrieve your stuff. Of course, all these also have their own cybersecurity. It's part of the things we have to look out for because of hacking. Hackers are usually one step ahead of those who the softwares. So, and challenge I'm not doing now. It's a form of video conferencing that Zoom is made possible. And the good thing about it is that all the things people do on their phone now, WhatsApp, Zoom, Imo, Google Duo, all also do video conferencing using those platforms. Then, of course, the home computers, then the VPNs, virtual private networks, which enables you to do a lot of, then, of course, voice over internet protocol, which gives back to some of the things we are doing now. Yes, next slide, please. Now, what do we need today as lawyers? And which is changing the face of the world. And this is also related to the point made by Judge Zana on the issue of liberalization. Facebook, LinkedIn, Twitter, and other such platforms are now very available to lawyers. Not doing lawyers' work is now very important. Lawyers, by professional ethics, we are prohibited from advertising. In other places, lawyers who advertise, they use some of these work, their legal as well. So I think that, like Justice Zana rightly said, law and technology cannot be street bent fellows if we want to make progress. And I think it's quite very clear. And while on that, I seem to agree with Justice Ogumiju, JCA, where we are today, given the level of our infrastructure and the architecture of our ICT, virtual hearing of trials is going to be very challenging. And I just the pilot virtual hearing at the High Court took place during this COVID, not even before. It's going to be quite challenging because of all the requirements. You have to look at the demeanor, you have to look at so many things. And because of the ability to Photoshop, which means that people can fake appearances virtually. I think there's a good meeting, JCA may have a valid point. But for all other things we do, appeals, adopt your briefs, you have objections, all the originating processes that has no oral hearing. Once it's not writ of summons, most of the other things we can do virtually. Yes, please. I will just try to make the point about COVID and legal practice, the way we do. My summary is we are now in the world of new normal. The COVID-19 phase of war, that is inclusive. We will be morning about virtual hearing, virtual submissions, about because of the impact of the pandemic, because of the problem of social distancing and things like that. So undoubtedly, the traditional way we were doing our practice has gone for good. So the way it is moving. Yes. Yes. And this is the point made by Justice Zana. Can technology actually drive away lawyers from existence as professionals? My answer is no. For those who artificial intelligence, robotics, and so on and so forth, you still need the human being to feed and develop all the itself. It still needs human agencies. So that is where we are. Artificial intelligence, yes, is there. And Justice Zana was kind enough to mention some of them. Is that, yes, we will have to adapt with what is going on. Lawyers are not likely to be wiped off the surface of the earth. Their services will still be necessary. But with interventions. So when you have that you can type in questions and you give answers. So, but all those notwithstanding, my view is that at the end of it all, lawyers may have to change the way they do their business. But we don't have any choice if we want to remain in business the way it is. But one thing we should all try to do, and one thing caught me as we were talking here, I was watching those who are taking part in this webinar, was that more than 30 years ago, we not have much problems in coping with the new normal. I think it's going to be much easier for our younger colleagues whose ordinary role are things we've been seeing. Primary school. So, and the time for older learners is how do you play a catch-up game with some of these younger colleagues who are already adept? They already know some of these tools. But my question is simple. Why we continue to make a place in the League of Conservative Profession, but we must live within the times that we find ourselves. Tools of technology, networking platforms, ICT generally must be must not be strange to us as lawyers. If we want to compete, especially in the global village and with liberalization of bigger parties, the incursions, but we cannot stop it. And I think to maintain our professional fidelity, we should all buy into that not overtaken and overrun by the rest of the world. Thank you very much.
Thank you. I'm Yusuf, a senior advocate of Nigeria. We didn't expect less, sir. And we have a lot that we will take away from your presentation, sir. You started by taking us on a journey of developments in the technology and how gradually technology crept into something that became useful to lawyers, that lawyers could tap into, the different tools that are available out there for quick research by lawyers. Well, you made a powerful conclusion by the traditional way of legal practice for good. Well, I know your first love is litigation, and you are a litigator by excellence, like I said. And somebody of your rank saying this, then we know that that is actually the way to go. You also try to talk about the place of old lawyers now versus some of our new and younger colleagues who are more adept at the use of this in the use of these technological tools. Well, I saw Charles was nodding his head when you are making that statement. The advice to old lawyers is that if you are not careful, these young boys and ladies will come and take over your legal practice. I'm sure Charles Ajiboye will say something about that when it is your turn. We have noticed from this end that various messages and questions were coming in as the presentations are being made. Some questions are directed specifically at specific speakers, while some are general. I want to assure all that we are going to attend to as many as we can after the full presentations. Thank you once again, Malam Yusuf Ali, Senior Advocate of Nigeria. The next presentation is going to be by somebody I call a barman to the core, Chief Emeka Ngige, Senior Advocate of Nigeria. Anybody that has met Chief Emeka Ngige will know that you never see him without a smile on his face. Maybe it's a permanent feature there, or maybe it's what he calls up all the time, but he has a huge capacity to face. He's a friendly, easygoing senior lawyer with a vast experience in legal practice spanning over 35 years. Chief Emeka Ngige is a principal partner in the law firm of Emeka Ngige & Co. based in Lagos. Like I said earlier, he's a consummate barman who has served the Nigerian Bar Association in different capacities. At the time, the secretary of the Nigerian Bar branch, and later he served as secretary of that branch. Presently, Chief Emeka Ngige, SAN, is the chairman of the Council of Education in Nigeria. We can really proceed that he is responsible for bridging the lawyer that will shape the future and the direction of legal practice in Nigeria. And by virtue of that fact, Chief Emeka Ngige is a member of the body of benchers of Nigeria. I now call on Ilan Sik to make his presentation. Thank you.
Thank you, Mr. Larewaju. I start by acknowledging my Lord Justice Inyang Okoro, the the special guest at this forum, and my Lord Justice Justice Kashi Zana, the guru, Nigerian technology law, Oracle. And then my fellow panelists, Kemi Pinero, our leader, Malan Yusuf Ali, and other participants at this webinar. Well, my task within 10 minutes is to discuss the paper Zana CJ. He has said it all, and this is a paper that was written in 2018. And in that paper, he sounded like a Nostradamus. And in doing so, he also quoted a portion from a paper by another Nostradamus called Mr. Steve T. Meha, who was a professor of law in Florida State University. Is very, very apt. He said that technology will transform the practice of law as it transformed the world. Newly available technologies like voice recognition, digital video, and high-volume data storage will create new protocols governing how agreements are formed and monitored and how disputes are resolved. The rise of technology, or more accurately, the unbundling of technology from servant of our wishes to master of our destiny, is about to take place for our eyes. The technology currently makes lawyers so much more productive and efficient, may soon escape control. Change their routines, challenge the inefficiency they enjoy, and form the foundation of a new practice of law. That was the standpoint on which my Lord started his paper. And he goes through this quotation from Stephen Maha is what is happening. Stephen Maha died in 2018, but from his grave, after the occurrence of COVID-19 pandemic, you will now see that the world is now being forced, whether we like it or not, particularly the legal profession, to adapt to technology. So, as we discussed, there's a saying in my area where a widow whose husband had just died, the family members were discussing about funeral. And the widow told them, as we are preparing for your brother's funeral, remember also the welfare of the widows. So that is what is happening. As we are discussing about legal practice, as it affects lawyers, we should not forget about legal education. Law school, from university to Nigerian law school. For lawyers to be relevant in this era of new technology, the curriculum has to be reviewed so that they will come out, they face the challenges squarely, and then they can find ways to overcome it. Otherwise, we may find ourselves like taxi drivers. The fate of taxi drivers in the advent of Uber. You call Uber, he will come at you and take you to their destination. So you can hardly see any anymore. Even at the airport, the challenge is there for the airport taxi car hire. Because passengers, as soon as they got their luggage, they use their handset to call the next Uber or boat driver or taxifier, as he used to be called, and take you to their destination. So that's what we face as legal practitioners, that if we don't prepare for the challenges, through legal education of ones that are still in school suggested, it may not be a signpost, rather, it will be a requiem to legal practice. So all hands must be on deck, all the stakeholders, Nigerian Bar Association, Council of Legal Education, body of benchers, we must all join hands to ensure that the challenges that we face is taken frontally so that lawyers do not resort to selling cement when there's no more brief to come their way or their office. So I suggest, as at now at the Nigerian Law School, they are teaching 5 courses: criminal litigation, civil litigation, property law, corporate law practice, and law in practice. So you can see from these courses that there is no full-fledged course for ICT. But all the same, the students, as Malan you pointed out, the younger ones who are coming from the law school now, the graduates and the new weeks, they have already started mastering the arts of technology. As at now, the law school is closed, like other educational institutions in Nigeria. But the law school management has arranged to be giving lectures online to students. They send it to them by way of audio, by way of video, by way of email, contactor notes, and the students do the assignment and give a feedback. So that is technology that is being deployed to avert what would have been a vacuum in the teaching of the law students, so that by whatever time that the schools resume, the students will not have lost much in terms of learning, in terms of teaching, in terms of education. So that's where all the stakeholders must help us, the council, the Bar Association, even Nigerian Law Publication Limited. You can donate your e-law reports to all the campuses of Nigerian Law School to help them, as Chief Gani used to do. Chief Gani was donating his Nigerian Wiki Law reports weekly to some educational institutions. I will urge the management of Nigerian Law Publication and other service providers in e-technology to deploy their CSR, corporate social responsibility, by helping the universities, faculties of law, helping the Nigerian Law School to have all these digital libraries so that the lecturers and the students will have access. And then when their challenges will be not as critical as those of us who are approaching 60. Like my Lord Ezana said, if you are 65 to 85, you are count yourself as one of the victims of the technological revolution that is sweeping across the legal profession. Then the Nigerian Bar Association also has a role to play, as Justice Dana pointed out in his paper. Some softwares now produce wills, produce agreements, produce contracts. The Bar Association has to ensure that the laws are kind of reviewed too, to make those documents, their validity, to depend on fixing of a stamp and seal of a legal practitioner on those documents. Otherwise, with these software that are coming online, the chances of the lawyers making it through commercial practice, nil. The other, we saw an advert by First Bank of Nigeria offering legal services. This is part of the challenge that Justice Zana is pointing out about non-lawyers trying now to practice law, albeit without the legislation being amended. So I hope Nigerian Bar Association will take it up with the First Bank and ensure that they obey the law of the land. As at now, without any amendment, they cannot practice law or offer legal services in the bank. So I join our presenters in saying that we are a threatened species, the legal practitioners, based on the advent of technology. So we must do what we can not to lose out, as they are already doing in America. We must ensure that we are up to date in our acquisition of the necessary technology. And on our own part, we shall ensure from the Council of Legal Education that the curriculum for the students are reviewed to make them prepared for the challenges of technology in legal practice. Thank you very much, fellow panelists and participants. Thank you for the attention.
Thank you very much, Chief Emeka Ngige, Senior Advocate of Nigeria. You have really absorbed our attention, and from a different perspective that we expected, you have brought it here, especially from the angle of the legal education in Nigeria. Because the Council of Legal Education, of which you are the chairman, is responsible for shaping the future of legal profession in Nigeria. And everybody here today has agreed that technology is even here, not the future. We're already here. The future is here with us. I think it's a bit regrettable that even the Nigerian law school have not deemed it fit to change their curriculum. Because presently, as stated by you, sir, there is no full-fledged course on ICT on their curriculum. I think even in secondary schools, in even primary schools now, we have emphasis on ICT. Chief Ngige spoke extensively to the paper presented by Justice Zana. You agree with most of what said, but more importantly, you used a practical analogy that everybody can relate to in reminding us about how, if we are not careful, the legal practitioner of today will become extinct, like the traditional airport taxi that has been taken over by Uber. I think we relate to that very well. Thank you very much again, Chief. I can come back during the question answer because I can see some questions are already directed at you. I want to remind listeners that we have on the panel the Honorable Justice John Inyankoro, Justice of the Supreme Court of Nigeria. We have Honorable Justice M. Moronkeji Ogunwumiju, Justice, Court of Appeal, and the Presiding Justice, Court of Appeal, Benin Judicial Division. We have Honorable Justice Kashim Zana, the Chief Judge of the High Court of Borno State of Nigeria and the Chairman of the Judicial Information Technology Committee. On the bar side, we have Malam Yusuf Ali, Senior Advocate of Nigeria, Chief Emeka Ngige, Senior Advocate of Nigeria, and Mr. Kemi Pinero, Senior Advocate of Nigeria. Of course, Charles Ajiboye. Well, there's no Junior Advocates of Nigeria yet, but you are welcome as well. So we are proceeding beautifully. Thank you for all the papers that have been presented. Questions and comments are coming rapidly, and we will attend to them in a not too distant future. I want to call on somebody I regard as my very good friend. He's a friend to many people because he's a friendly and amiable person, always smiling as well.
It's 12:15.
And every time you see him, he looks younger than the previous time that you saw him before. Maybe he will tell us some of the secrets here. Probably technology, because I'm not a strong and ardent advocate of technology. Maybe he will let us know whether that's partly responsible. Mr. Oluwakemi Pinero is a senior advocate of Nigeria. He's a fellow and lecturer of the Chartered Institute of Arbitration of Nigeria. He is a member of the Institute of Directors, United Kingdom. And presently he's also the chairman of the Law Reform Commission of Lagos State. Mr. Pinero is a legal practitioner of over 34 years at the bar, and he is highly noted for his industry, clinical efficiency, with a great passion for advocacy. Those who have seen him practice in court will attest much to that. Of late, he has been involved in a lot of work and commissioned publications. He is one of the leading crusaders for the need to embrace innovation and technology in our court proceedings. He's also been in the thick of the argument as to whether virtual court hearings are constitutional, the way our constitution is now, the 1999 constitution as amended. I'm sure he also has a little bit of his perspective on that. I welcome Mr. Kemi Pinero, Senior Advocate of Nigeria, and the head of the law firm Pinero LP.
Thank you. Thank you very much, Mr. Ayerebaju. Let me first of all start by saying that I stand and I wish to hug the team protocol established by the chairman, the Honorable Justice Okoro, Justice of the Supreme Court. I must also thank the moderator and the Nigeria Weekly Law Reports for giving me the opportunity to share this platform with very eminent and revered jurists, and together with the most iconic and highly successful senior advocates. This is an opportunity that I do not want to miss, and I thank you for that this platform. I will be talking about the constitutionality of virtual and remote court proceedings in Nigeria. I recognize that this is a topical issue. I recognize that since we are talking about tech, it's about time we focus on this aspect. But the best way to start is by where Honorable Justice Shim Zana, the computer judge, so to say, in the paper he's just delivered, is a paper that very interesting opposite. He is that the legal marketplace of tomorrow cannot be immune from technology that will permeate the socio-economic fabric of society. He now states, he said, paper-based practices and practitioners will surely be as extinct as dinosaurs today. I think that is a very opposite statement, and it's important that we bear this in mind in the course of my paper. The efficacy of any judicial system is gauged by the capacity to provide timely, appropriate justice to parties in dispute. It is without a doubt that the Nigerian judicial system, despite all attempts, still falls a bit short of that mark. I'm also glad that my Lords, Justice Okoro, Justice Ogunwemiju, and eminent senior advocates, Messrs. Yusuf Ali and Ngige, also share the same view that the judicial system in Nigeria, particularly also from the aspect of must compete from the technology. We need greater access to justice. We need faster judicial processing and less delays. And we need increased judicial certainty and predictability, amongst other things. Many people have called for technology-based solutions. I recognize the fact that the NJC just initiated the guidelines for technology, particularly in relation to the COVID-19 pandemic. But by and large, these calls and these directions are yet to achieve most of their desired results. The truth is, technology is with us and must be effectively utilized in our dispute resolution processes. Let's do it from it. As the artificial intelligence, as the lead speaker has put it beyond doubt, that artificial intelligence has been at work in legal research, in e-discovery, in case prediction, and also document automation. I say that artificial intelligence has made lawyers to devote more time to more valuable work because it makes our work much, much easier. Regrettably, arbitration that came after the court system has left the court system far behind. Arbitrations now, you can sit in one part of the globe as the claimant's counsel. The respondent's counsel can sit in another part of the globe, while the arbitrator is another completely different part of the globe. And witnesses are in another country entirely. And arbitrations are carried out effectively and efficiently. I note the assertion of the lead speaker, the lead speaker in the paper when he said ability, affinity, stability, and agility. I have taken that home, and I'm hoping that most of the legal practitioners who are on this platform hold that there and try to retrain themselves to understand the importance of those 4 points. One pertinent area of technology application to law is that the subject to debate is the question of virtual court proceedings. This has agitated the minds of a lot of legal pundits, and some of us, we need a constitutional amendment before we can conduct virtual hearings. I intend to treat this point in the little time that I've been given, 10 minutes. But let me first of all share with you some of the statistics I have mined for this webinar. Nigeria is ranked 106 out of 126 countries in civil justice. In criminal justice, we are ranked 79 out of 126, 76 out of 126. And the World Justice Project, Rule of Law Index. Presently, we have over almost 52,000 awaiting trial inmates who have suffered setback, whose trial have suffered setback because of the COVID-19 restrictions and lockdown. That is the equivalent of 70% of all inmates in our correctional institutions. While we're still at this and we're arguing on the utility of virtual court hearings, Singapore conducted 219 virtual trials, not hearings, virtual trials in 2 months. That is April and in May alone. I was able to get this information with respect to the cases that are pending from the internet. But I want to focus attention on the interlocutory applications that are pending. I have hazarded a guess based on the number of cases that are pending in the trial courts, the intermediate courts, and of course in the Supreme Court. And I have come to a realizable assessment that probably we have about 1 million, almost 1.6 million applications that are pending. The question I want to ask our participants is, do we need to have these applications to be heard and determined in person, physically in the court? Can't these applications have been taken virtually and remotely and free the court system to take more in-person trials, as Justice Ogunwemiju has ably put it, rather than having these cases congest our court list? Please, it is interesting that we have, let me give an example. We have 16 divisions of the Court of Appeal to serve 36 states. A litigation that is commenced in, say for instance, in Gombe, you will have to go to Taraba State to do the trial, to do the appeal. If you commence in Kebbi, you will have to go to Sokoto to do the appeal. As far as I am concerned, I think if the Court of Appeal leverages, just like every other court, leverages more on virtual hearings and virtual proceedings, it will make a lot of appeals move much faster. And there will be a drastic reduction in those numbers, the over 10,000 cases or more that are pending at that intermediate court. Let's take the Supreme Court. We have just one Supreme Court that is located in one area, in the Federal Capital Territory. All courts, all appeals from intermediate courts have to go to that location. And oftentimes at great cost and at great pressure to our infrastructure. Must the Supreme Court continue to conduct interlocutory proceedings in person? Most of these proceedings can be conducted virtually, such that a non-contentious application, aside from being taken in chambers, even if it's contentious, I can sit in Lagos and conduct a contentious application before their law lords. Now that takes me to the next point, the constitutionality of the use of the technology in court proceedings. Let me confess my bias from the onset. I'm a very strong advocate that we do not need an amendment. I also recognize in advance that there are cases that are pending with respect to the virtual court hearings. But unlike Honorable Justice Ogunwemiju, my own hands are not tied. I can proffer an opinion. And this is my own view. We do not need any amendment to conduct virtual court proceedings. We do not need constitutional amendment to conduct any form of remote hearings. We have to first of all understand what is the Constitution. The Constitution is an organic law. It's a substantive law. It's not a procedural law. So you cannot infuse into an organic law procedural prescriptions to guide how an institution will conduct its affairs. Let me give an example. In Kenya, that has a similar system that we operate. In Canada, that has not so similar system. In India, not so similar, but almost similar too. They are federating. And in the United States, they all have written constitutions. I challenge the participants to peruse any of those constitutions and see whether there is any provision in those constitutions for remote or virtual hearings. Yet, each of these countries have leveraged on technology and they have conducted virtual proceedings. Nigeria cannot be any different. Understood from the standpoint that the Constitution does not deal with matters of procedure, the next question is this. Let us look at the entire gamut of the Constitution. Is there any provision that prohibits or can be said to impliedly or expressly prohibiting virtual hearings? My simple answer to that is that no such provision exists. The only provision that will probably be relevant for our discourse is Section 36(3), where it is said that the provisions shall be held in public. And all the protagonists of the constitutionality or unconstitutionality of virtual hearings have always relied on this to say that the word public implies that, it must be in a courtroom. I say found them in the section 36, whether it's subsection 3 or subsection 4 or subsection 6. No reference is made to the word courtroom, building or place. And it was not, a court was not designated in the Constitution as a room, building, or place. Professor Richard Susskind has put it most eloquently. He said, is the court a place of service? I also note that my Lord Honorable Joseph Uemiju also stated that we need to recognize that the judicial sector is providing a service. And so if we recognize that it's a service and not a place, in which case not a courtroom, then our interpretation of Section 36 should embolden us to recognize that it permits and does not prohibit virtual court hearings. Like I've said, what is not prohibited is permitted. And this has been the position even as far back as 1987, when the Supreme Court was faced with the question of computerized evidence. Even though there was no provision in the Evidence Act, my lords and the law lords were able to navigate and came to the conclusion that it's important to state that a computerized account does not fall into the category of evidence absolutely inadmissible by law. In my opinion, it falls within the category of evidence that is admissible. They were able to navigate and also chart that course. Now, each of the actions that have been issued by the heads of courts are anchored on the enabling provisions of the Constitution that empowers each of those heads of courts to make those practice directions. So in fact, each of those practice directions also have the force of law and they are constitutional. Do we then need to amend the Constitution to infuse these procedural issues into same? I think not. Like I've said before, what is public? In the simple adjectival sense, according to the Cambridge Dictionary, it relates to all speech in general. That definition is not limited to a courtroom, to a room. It's about involving people in general. The law lords had in Koshebino and Alimi opined that public is a place that is outrightly accessible on the basis that no permission is required of a judge. I also concede the fact that what they had to contend in that case was the judge's chambers. And all the cases that have often been cited by protagonists have been either the Koshebino case, the NAB case, the Edibo case, to buttress the contention that, it has to be a courtroom. But we all agree, and that is the state of the law, that principles that evolve in cases take their peculiar facts take their root from the peculiar facts of those cases. As far as I am submitting, and I'm relying on Belgore GSC's reason, that hearing in public entails simply a situation where the public is not bad. And to that extent, any virtual platform, whether it's Zoom, whether it's Team, howsoever, whether it's Skype, meets the tests and is sufficient to guarantee access by the public. Now, what do we need to be able to confirm to ourselves that it is constitutional? What we need to look at is, so first of all, let us see how the attitude of the Supreme Court of India, even just recently as far back as in 2007, they said the use of modern technology needs to be considered not only for the paperless courts, but also to reduce overcrowding of courts. There is need to categorize cases which can be concluded online without physical presence of the parties, where seriously disputed questions are not required to be adjudicated like traffic challenge. In another case, they said there's no reason for courts which set precedents for the nation to exclude the application of technology to facilitate the judicial process. Imposing an unwavering requirement, I dare say, such as interpreting Section 36 in a limited manner, that it relates to public relates to a courtroom, unwavering requirement of personal and physical presence, and exclusion to video conferences will raise justice. In Canada, just very recently, I think about a month ago, this is what their law lords said at the Court of Appeal in Ontario. A counsel had expressed a preference for taking the panel through the arguments during an in-court oral hearing at a future date. That preference is understandable, but it is not in the interest of justice. Moreover, it is not in the interest of justice to overburden the court by adjourning matters that can be dealt with fairly as scheduled. The backlog that will be created by cases that must be adjourned to protect the public and ensure fair hearings will be imposing, and it should not be unnecessarily aggravated. The reason why I've taken the pains to refer to other jurisdictions is to be able to trigger a mindset of their law lords when faced with any appeals or any objections as it relates to technology-based solutions. And they've adopted this attitude before. In Dakwambo and Abubakar, they said they held in adopting a very purposeful interpretation of the Constitution. They said that there's nowhere in the Legal Practitioners Act which says that the names enrolled in the role of legal practitioner cannot be abbreviated and initialed. It is the cardinal principle of law that what is not expressly forbidden is permitted. Even in as far back as 1981, in Attorney General of Federation, they said words of the Constitution are therefore not to be read with stultifying narrowness. In the not so recent case of FRN and Fanika, they are admonished that our judges must refrain from to make laws from the bench. They must not shy away from adopting a proactive approach to the interpretation of the law. Judicial officers must not place on themselves disabilities not imposed by law. Of course, even recently in Theophilus FRN, they said it is not within the court's interpretative jurisdiction or powers to construe a statute to mean what it does not mean, nor to construe it not to mean what it means. Having said that, all that is required, and all I urge our courts, whether at the trial, intermediate, or the apex court, is the purposeful interpretation whenever any objection arises as to technology-based solutions. Finally, I thank my Lord Justice, Honorable Justice Okoro, who said that our focus should not be on the problem. Our focus should be rather on surmounting them. And I commend to the participants and everybody listening this pronouncement of the Supreme Court of Canada when they said, and we are adapting, but nothing is perfect the first time. Just remember that we are here for your arguments, not the angle of your camera or your facility with your familiarity or facility with mute button. We will get through this hearing, just as we will get through this pandemic. I submit, sir, that this pandemic has given us a fantastic opportunity to take a second look at technology-based solutions in order to increase the efficiency of the justice delivery. Thank you very much.
Thank you very much, Mr. Kemi Pinero, Senior Advocate of Nigeria. At the point there, I probably thought that you were making submissions before the Supreme Court. Of course, we have Justice Okoro of the Supreme Court here, and Justice Ogumiju and Justice Zana. Very powerful submissions. And every of your opinions shows that it was a well-researched opinion, because every opinion was backed by copious authorities from different jurisdictions. I think you have enlightened us a lot. And your argument is very convincing, especially about the fact that there is actually no need for the amendment of the present Constitution of the Federal Republic of Nigeria 1999 before we can resort to virtual court hearing. You have always held that opinion. I think at every opportunity you have, you make that opinion more powerful. And I'm sure maybe you continue to research on that. Very convincing argument. And thank you for that. We also thank you for the statistics that you shared with us about the ranking of Nigeria in civil and criminal proceedings. These are very worrying statistics that you have shown us. And we hope the relevant authorities are hearing and will look into this, as well as the statistics about the number of interlocutory applications that are actually pending in our courts. Over 1 million. And I think that is the opportunity that we need actually to clear the whole of the backlog of these applicants. Thank you once again, Mr. Kemi Pinero, Senior Advocate of Nigeria. I can see some questions already coming in for you. I will take those questions at the appropriate time. We are moving on towards that now. But before we do that, let us listen to the young man in our midst of the panelists, Mr. Charles Ajiboye. He's a young lawyer who's already making waves. And this technology appears to his generation, Ghana. So let us hear the perspective from the young generation. Charles Ajiboye, the former chairman of the Young Lawyers Forum of the Nigerian Bar Association Niger branch. You have 5 minutes to make your presentation. Thank you.
Thank you very much, sir. And I'm indeed honored to have been given this rare privilege to speak before my mentors, some of whom were called to the bar even before I was born. I'll run straight to it because my Lord, the late speaker for today, Honorable Justice Zana, has helped me to save my time because he conveniently took over half of my presentation. And so I'm excited that I really do not have much to say anymore. I'll just run straight into it and I will share my screen. I will skip as many slides as I'm convinced that Honorable Justice Zana has already taken for me. Technology and law practice. A question keeps coming to my mind every time I think about technology and law. That question is a very simple question. It's the question of what exactly is the essence of lawyers? Why do lawyers exist? In what ways are the buyers and sellers of legal services better off? Because a law firm is the platform of choice for their transactions. The truth is that, whether we like it or not, there is a reason for the existence of lawyers. And if we are not clear about the reason, we will be fighting technology, we will be fighting the opportunities it brings without knowing that we are fighting ourselves. There used to be a company called Red Card in Lagos. And Red Card did not know exactly their essence. They thought they had a business of buying taxis. Meanwhile, their business was not in buying taxis. The people who make films at some point were so concentrated on multiplying CDs, duplicating radio cassettes. But indeed, their job was not in producing CDs or cassettes. And I'll give another example, and I'll say Nigerian Weekly Law Report too. Their job is not necessarily to produce or publish yellow bounded books. No, their essence is a lot more than that. And we as lawyers must identify our essence for us to be able to understand how technology will make a difference. I'll tell a story very quickly. The story of Kodak. Kodak was the biggest name in photography. And many of my mentors, Silk and honorable justices in the House, recall the story at the time of Kodak. I, as a child, remember Kodak. And Kodak was the biggest name in photography. They made cameras, they made films, they made papers for printing of the photograph. They made technology to print it. And then they had an opportunity to remain in business and to remain the biggest people in business. But they bungled it because they failed to change at the time they ought to change. And we are at that point again, as lawyers. We are at that point where we need to change, and we need to change very actively. We need to change very fast. I thank the leadership of the Nigerian Nuclear Report for considering me to be here. I feel swallowed with the kind of titans that you have put me there. But I think that the only reason why you might have considered putting my humble self in this panel is because there is a need for us to transit from the generation of the likes of Honorable Justice Zana and the Leonard Silks in the House into this time, because if we do not bridge that bridge very quickly, then there will be a problem. Technology is actually an advantage, and that's why I put a double D there. And that advantage is what we need to deal with. Leonard Senior and Leonard Silk, Mr. Kemi Pinheiro, said a lot about virtual hearing. But I really want to take the position that if we are talking about the impact and the necessary improvements that technology will bring to law, we must go beyond virtual hearing. There were a lot of things that Honorable Justice Zana said, and he did not even talk about virtual hearing. Virtual hearing is so minute in the scope of things that technology is about to bring, and it has already brought. Zoom is not the future. Zoom is not a big deal. I, as a person, have been using Zoom for a long time. Many of us have been using Skype for years. Zoom is not a testimony. Skype is not a big deal. Virtual hearing is still. We need to start having much more important conversations. This was how BlackBerry took over the space. They got themselves, they were the king of the market, and they remained at that level. The whole world left them, and they were still talking. Now the whole world is leaving us, and the whole economy is leaving us, and we are still on virtual hearing. We are still on whether it is constitutional or not constitutional. I love the introduction of Leonard Steve, Mr. Pinheiro, when he said that there's a lot more to deal with. The world has left physical courtrooms. How we will deal with these virtual courtrooms? Imagine 1.5 million, assuming the statistics are detailed. Imagine 1.5 million pending applications. Oh my God! It's unthinkable for people in my generation. And the truth about it is that the disruption we are facing is actually a big opportunity. The question I will keep asking is, are we seeing it? Are we seeing these disruptions? And I will go back to my question, which I will answer in my last slide. What exactly is our essence as lawyers? Why do lawyers exist? Is it because we want to go to court? Is it because we want to get people out of jail? What exactly is the essence of lawyers? The truth about it is that technology will continue to run faster than law, and that is okay. That's not a problem. The problem is how fast is the law running after technology. Leonard Silk and mentor Mr. Ngige said something very instructive when he gave the example of the First Bank story. And I'll quickly stop this sharing, and I'll share a screen in the second too. You see, it's not enough to be worried about First Bank. We need to go beyond even First Bank, because the world is even more than that. I don't know how many of us have come across this particular website also. They are already creating agreements. And if you look at this side of their website, this is a live website I'm sharing. For any property that is between 0 and 1 million naira, an agreement costs just 20,000 naira. 10% would have been a lawyer's fee of 100,000 naira. For 1 million to 2 million, it's just 50,000 naira. And for 2 million to 500 million, it's just 80,000 naira to purchase an agreement. And guess what? That website provides a lot, and you will feel it, like we have discussed here, right there. We cannot fight that technology. We can't fight First Bank. We can't fight Union Bank. What we need to do is to grow the law. We need to grow that law, and we need to grow that law very quickly. Honorable Justice Zana has helped me. He has taken this part of my slides. He has also taken this part, and I'll just keep to the ones he has left me to deal with very quickly. Now, this is what a new lawyer looks like. That's the lawyer on the left, and that's robot on the right. Whether you like it or not, there has to be such a synergy that the brain of a lawyer now works like a robot, and the robot now houses a lawyer. We will never be able to substitute each other, and that is the truth. But we will need to have our heads together and function effectively together for us to remain productive. Now, for us at the firm, for example, in the last 3 months, my firm has not been able to resume. We have been working remotely. But 70 to 80% of the work we have been done falls in the category of digital legal services, which requires on-the-spot, live, immediate, prompt provision of legal opinion in multiple formats to different clients across the globe. And we are able to function effectively. Lawyers will begin to need, are now in the process, in the time where we need to start thinking about specialized, bespoke services. It's not going to be about writing a proposal to a law firm or to a company to retain your services, and then when they retain your services, they'll bring briefs to you and agreements to review. In fact, we stopped doing that long time ago. And the biggest of our growth to engage about 20 millennials is not even in all those areas. Now, lawyers have to get to a stage whereby you write proposals to organizations, not because you want them to retain you, but because you have identified the problem, which there's a legal solution that you can provide, and then you position yourself as lawyers and the only ones who can provide that service, and then you go ahead and do it. What all these people, Union Bank, First Bank, Nigeria Property Center have done is what we call productization. I'm not sure whether the grammar is in conformity with anything. But what it means is that lawyers also have to get to a level whereby we'll make our services into products. The truth about technology is this. It's only supposed to, the essence of technology is to make things easier, faster, and cheaper. But it still does not mean we can't make the billions and the hundreds of millions like Leonard Seals that are in-house here. There are many ways to kill a rat. The way we have been killing it is just the way we are used to. And there is a new way to do all of these things. The walls are down now. And that is the truth. The walls are down now. We must understand that the essence of lawyers cannot be for a few. I'm not sure we have up to 200,000 lawyers living and dead in a country of about 200 million. We are grossly underutilized. We are grossly underengaged as lawyers. And for us to be able to meet anything close to our audience, for us to be able to meet anything close to our relevance, the truth about it is we will need to productize. We will need to apply technology to improve our reach. I'll touch very quickly before I round up on the issue of curriculum, because I like the fact that Leonard you can mentor Mr. Ngige mentioned something about the law school. It all starts from there. When the law school started about 10, 15 years ago to insist that law students must own laptops, it changed the dynamics of law practice. Now, the law school must lead this game. The law school must take the bull by the horn and pioneer this change. Law school cannot continue with a syllabus that people like us that left law school about a decade ago they're still using that same syllabus. It's impossible. Technology is growing on a virtually a daily basis, and it's not possible for us to be churning out lawyers with a curriculum that is more than a decade old. It is sure they cannot be relevant. And so ICT is not a course that law school should think to introduce. ICT is not going to be a course anymore in the new normal. Technology is the way of life for everybody. There will be no such thing as an into ICT. There's nothing like that again. Every lawyer must understand that legal services must be provided using technology. The bench must understand that legal services must be deployed using technology. Doctors must understand that legal services must be deployed using technology. Publishers must understand that legal precedents must be produced using technology. And so ICT is going to be embedded into every area: criminal litigation, civil litigation, corporate law practice, property law. Everything must contain ICT, and we must begin to teach the next generation of lawyers how technology can be deployed to maximize those areas of law. And that's what is going to change the game. And I'll round up on this before I get to the answer of my question. And this is good news to every young lawyer that is on the board, that is in this webinar. And I've been excited about this part. I call it the rise of the underdogs. The underdogs is a cartoon many years ago. And the underdogs are people who are shy, intimidated, oppressed. You are not expected to succeed. You are not expected to shine. You are supposed to bid your time. And that's the description for young lawyers. You must wait. You are small fries. And then, in fact, if you win, then things are going to go wrong. It's a problem for you to win. And I'm glad that some people like Leonard Silk and mentor Mr. Kemi Pinheiro are beginning to tap into that. I saw recently the appointment of a new partner in his firm, and I could see the gap between the Leonard Silk and that partner. And I said, Leonard Silk is just plugging into the future. Because that is the opportunity. Now is the opportunity for the underdogs. The underdogs are young lawyers like us. People like us who would never have had a say or relevance. But now, networking has changed. Not everybody needs to be members of the Koi Club anymore or members of the golf course. No. You can meet virtually anybody by subscribing to a licensed account on LinkedIn, and you can meet the world. And that is literally so. The world in one button. And that is something that the underdogs can use. They can use the gadgets very well. They understand software. And I will say to my Leonard Silk and mentor also, Malam Yusuf Ali, people like that can remain in practice forever if only they will practice collaboration. If only they will start thinking about things like mesh business. Mesh business is the kind of thing that people like Uber are using. That is, they own no car, but they have thousands of taxis world over. Yes, I'm on my last slide. They own no pictures, they take no photographs, but they own billions of photographs. Facebook produces no content, but they have millions of content every day. Law firms, lawyers must begin to think about a way forward and ask themselves, why do we exist? If you know why we exist, then you will not have a problem with doing all the things I've said. I think, and I beg to be wrong, I agree to be wrong, especially when you are speaking to mentors like this, that the essence of lawyers is split into two things. Number one, to help clients to make and to save money. Number two, to help clients get peace and or justice. Now, how we do that could be arbitration, mediation, litigation, drafting of agreements, and all of those things. But those are the means to the end, and this is the end. Technology can take
Thank you very much.
In many ways. Thank you very much for the opportunity.
Yeah, sorry. First of all, let me apologize. I will give you only 5 minutes. I know you will do with 30 minutes if we give you that as well. Well, you hit the nail on the head when you said, when you try to reason, to answer the reason why we brought you in here to this panel today. Well, we wanted to hear it from because I mean the general belief that technology is more friendly. I mean the youth or the young generation, it's as if the technology is made for them. Yes, we have heard from your perspective, and you have brought another dynamic into it. I can see that your paper is very rich, and you have a lot of advice to give as well, especially for the curriculum of the law school. I can assure you, I introduced him earlier, Mr. Nasiru Tijani, the Director General of the Nigerian Law School, Lagos is here. And I'm sure he must have taken away one or two things from what you have said. Yeah, I did mention earlier that all the papers that have been presented today, we are going to place them on the website of the Nigerian Law Publications Limited and will be accessible to anybody that goes into the website. Additionally, for all those that have registered for this seminar, we are going to post the papers to their emails directly. So if you have registered and we have your email address, we are going to post the papers to you. We will also put it on our website. Thank you very much, my Lord Justice Okoro, my Lord Justice Ogunwumiju, my Lord Justice Zana, Senior Advocates of Nigeria, and Charles. The questions have been coming in thick and fast. Some of the panelists, I'm sure they have seen some of the questions. We have some of these questions directed at specific speaker. Some of the questions are to all the panelists. I think we'll just go through some of the important ones. The ones that we cannot answer today, this session is being recorded. We'll provide the answers and also send them to the email addresses of those who have asked the questions. While we were on the last leg, we have one of our justices, the Honorable Justice Alvan Fube Eva, came in and joined the proceedings. Mr. Dalami from Taraba State, magistrate in Taraba State. Mr. Kende Ogunwumiju, Senior Advocate of Nigeria. In fact, he asked a question that we are going to pose to our panelists. In the audience here, we have Chief Chris Uche, a Senior Advocate of Nigeria, a very senior lawyer. I think he's still around. If he's here, he wanted to ask a question or make a comment. I've promised that we are going to give him a minute to do that. Chief Chris Uche, please let us bring on Chief Chris Uche. Yes, Lord Justice Okoro, I would like to have your direction as to how you want us to do this, sir. There are some questions addressed to all the panelists, and there are specific questions addressed to specific speakers. So,
I don't know the time that you have for the question and answer session, but we try our best to see those questions you term as important questions. We can take them first, and if we have time, we take the rest.
Yes, my lord. We have 20 minutes for the question and answer session. I will want us to take the questions that were directed to all the panelists. Maybe anyone can pick up any of those questions. We have a question from Mr. Chika 1106. I will quickly fish it out. Just a minute.
I think Chief Chris Uche is around.
Oh, he's here now?
Yes.
Yes, I am here.
Chris Uche, nice to see you, sir.
Thank you so very much. It's been a highly enriching webinar. I've been tremendously blessed, and let me thank my lords and all the panelists for this very, very engaging session. Quickly, I wanted to commend the Nigeria Weekly Law publications, but to observe as a user of their online reports that I always have a difficulty scrolling through the pages. And this is the thing you have introduced is very, very welcome, because as an old user of the Nigeria Weekly Law reports, even when I go on the Law Pavilion online to find authorities, I still want to come back to the Nigeria Weekly Law reports to get the appropriate citation. So I need to know what you can do to make scrolling of pages very adaptable and easy, and so that going forward we can maximize our use of that. That's just the question. Then on the issue, my Lord, Honorable Justice Enyan Okoro JSC, in his contribution, the proposals, he made reference to a situation where even briefs before the appellate courts, lawyers need not come to the courts to adopt such briefs. You can adopt by remote connection. So my view is, if you look back and see what this method of adoption of written addresses and adoption of briefs, what it has done to oral advocacy, as we have experimented in the past 2 decades. I was asking whether now removing the lawyer from coming physically to adopt the brief of argument, whether that will not lead to further decline of our oral advocacy. Because just like Chief Emeka Ngige pointed out, what has happened in the Oba case, a situation where the lawyer is now seen just as a middleman in law or justice market, which is between the litigant and the court, and the lawyer is just a middleman. Will they not get to a situation of eliminating the middleman from the entire business if even the little opportunity to come to adopt a brief of argument is deprived of counsel? I think a little clarification may be necessary in that area. Thank you very much.
Thank you, Chief Chris Uche. Let me quickly address your the little problem you are experiencing with the Nigerian Weekly Law Reports. You will notice that when we first of all came online,
yes,
the ability to scroll from page to page, it was the policy of the company. We didn't enable it at our first offering because of some security issues, with where people will want to make photocopies or download into some other, but we have gotten a better technology, and you will see that now it has been enabled. That is still ongoing. So I can assure you, yes, within the next few weeks, the system is going to be perfect with regard to rescoring, because we discovered that is the best way that you can utilize the online version, the ability to scroll instead of having. Thank you very much, and thank you for participating. So I leave my Lord to answer the question you have. Lord Justice Okoros, I think you directed your question at my Lord Justice of the Supreme Court.
Yes, I directed. I can repeat the question. My Lord Justice Okoro JSC, you made the point that there may be need as a proposal in this remote advocacy where lawyers need not travel all the way to the relevant courts in order to adopt their briefs of argument. Once it is filed, it's considered filed and adopted. And I am asking, in the process, for instance, of an appeal, that point to adopt is the only legal appearance of the lawyer before the court. If you now deprive the lawyer of that, will that fail the development of oral advocacy, which we have seen that with the backdrop of what we have seen in even adopting of briefs, as against those past years where we did not have written arguments, we came, we studied, and we argued. Will that not further lead to a decline of oral advocacy? That's the question I posed to my Lord.
Can I answer it now?
Okay, sir.
Well, I think the whole thing boils down to the issue of case management. I did say that it's not all cases that could be heard virtually. And that issue, that point I made was during the COVID-19 period. Okay. That instead of allowing the matters to lie down there, we can hear these matters virtually. And I did say that what is there, if a counsel has filed his brief and his exchange of the papers during this pandemic period, it can be adopted virtually. You stay in your house and adopt your brief. The other counsel stays in his office, adopts his brief, and judgment will come out. You don't need to come to the court since the virus is still raging. Do we need to wait until the virus is gone? Then we come to court to argue the matter physically. that would not be in the best interest of justice for our people. For how long will they wait? You know, that was the basis that I said that as we are now, you know, we don't need to wait again. Those matters that in the cost management procedure, the court decides that this one can be held virtually. Then parties could be notified. You stay in your office, adopt your brief, which you had written and exchanged. And remember that even in physical hearing, you bring your brief and say, I adopt my briefs. You want to adumbrate. The court says, all these things you are saying, are they not in your briefs? You say they are written in your briefs. Say, please, just don't waste our time. The other counsel. These are things that we see every day in court. You know, file motion now. There is something we used to have, a certificate of non-contention. Counsel says, I'm not going to contest this motion. Why should we bring you to court? To come and say, we are not going to contest. You can file the form, the certificate of non-contention, and you stay in your house and say, I'm not contesting, I have filed this. Why must you fly to Abuja to say just that I don't want to oppose this motion? That can be done virtually. I don't think it will take away your argument. The argument is already in your brief, which you sat down to say it, except you want to say it openly to impress your client that at least you can do one or two things in addition. So that is the from where I was coming from, that during this pandemic, we can use that. Maybe after the virus has gone, if we want to go back to...
Thank you, my lord, and thank you, Chief Uche. I'm sure you continue to listen. The next question is for Honorable Justice Zana. My question is whether our Practitioners Act and the rules of the professional conduct do not limit the use of some of the identified technological innovations, especially those provisions that prohibit the practice of law as corporations, and that only a person called to the Nigerian bar is eligible to practice Nigerian law. That is a question from Ikeme Funa.
Yes, thank you very much, Ayo. These are the issues that in the paper you will see some details that will answer it. Yes, there are laws and practices and ethical standards that are impediments to these things. But the point being made, and I'm glad Charles has come in very, very forcefully. It's young men like Charles that make me sleep sometimes, otherwise I may have developed hypertension. Yes, there are impediments, and even in the course of this webinar, we've heard of it will happen because the society has an interest to protect. They want cost-effective services, and technology will assist that to be deployed. In fact, it's not even going to be, when you read the lecture, you see, it's not even going to be just the society versus lawyers. You will find that the law family too will be divided. I see these young lawyers. Are they really happy about how they are treated in some of these, our own type of big firms and all these things? So when the society wants legal service, because education is going to expand, more legal services will be demanded, and the way we practice law now, if it continues, that means many cannot afford it. So when the demand becomes strong, and then they have examples from elsewhere where these alternative legal services and on-demand legal services are being provided, and the society agitates for it, you will see that there is pressure. And then you will find that the legal family too will be divided. There will be the young lawyers, the Charleses, and even the younger than the Charleses, who are being paid pittance by the work for 1 million instead of 10, 20,000 naira. And you will see that now the profession itself, there will be half of it on the side of society for change. So when these things happen, you just can't resist it. So it's better to be agile, better to develop the affinity, better to develop the ability, because these things are going to come. Incidentally, right at this webinar, I've been enlightened now. In the chat section, One young man referred me to already existing now in Nigeria, a gigging law firm. I don't want to mention the name so that I'm very cautious about being advertising or something. I never knew that gigging had arrived when I was writing this lecture 2 years ago. Even this time, I didn't know that it started. But then on the chat, if you scroll down, you will see gigging has already come. So you see how you cannot resist some of these things. Charles has already now referred to the case of, I believe that's a chatbot service, the one that he now showed live. It's the same thing that LegalZoom or Do Not Pay is structured around that. And it's the same technology that provides these services, whereby persons can now go in, pay some small money, and draft their tenancy agreement.
Rocket Law.
Good. Or Rocket Law. There are so many of them. Now, this thing about it has to be a lawyer, okay, fine. Charles and his colleagues will put that online, draft it. They are lawyers. After you utilize the service, they stamp it. And I assure you, with the legal mail coming now, and if the Bar Association is going to cooperate with us, your stamp, the stamp that you now put, is going to be an e-stamp. In fact, better secured, protected by blockchain. And this time around, there will be no shortage because we are not printing anything. Bang! You go to their site, draft your agreement, and then with the same technology, Charles and his younger guys will stamp it, and it's produced by a legal practitioner. Let me see how you can defeat this one in court. You can't stand in the way of technology. Better shape up or ship out.
Thank you very much, my lord. Thank you. There is an anonymous attendee here who has a question for my Lord Honorable Justice Ogunwumiju. He says, since lawyers and judges are service providers in the justice sector, as rightly pointed out by Honorable Justice Ogunwumiju, is it not time for us to reconsider our position on advertising in this technological era?
A very interesting question posed by that participant. I'm aware of the very stringent advertising law relating to the legal practitioners in Nigeria. I think it's an inheritance of the way lawyers were conceived in the olden days when the legal profession was introduced into Nigeria. I don't know whether, I mean, everyone knows that in America, that does not happen. You can advertise, you can even dance and advertise your firm. I don't know how much, whether the lawyers in England still have as much restriction regarding advertising as we have now. Because with the Reform Act that was passed, that Justice Zana referred to, that makes it possible for non-legal entities to even own law firms. I don't think that occurs again in England. And so we must choose what we want. We must choose what we want in Nigeria. Do we still want that strict prohibition about advertising? Because really, we are service providers. You go to the person that can provide the best service. Because sometimes, I'm sorry to say, in court, I mean, I tell some lawyers, see, your client has entered one chance. That's true. That client just entered one chance. If he had better opportunity, he would have gone to a better lawyer. At least if he knows that this one can provide this one can provide that, this one can provide that, then he can ask around. Ask of these service providers, who is better or who is the best? I have my money. Oh, I can afford this person. Who is the next best I can go to? Because that is what is killing us in the legal profession. I believe that these are part of the solutions that can save us from this collective, I think, I don't want to say suicide pact that both the judges and the lawyers are in now. Because the normal litigant will say, hang all the lawyers and judges. So if you don't want us to be hung, all of us, let the litigants have a choice. I don't have anything against advertising. if that answers your question.
Thank you, my lord. That dovetails into the question asked by Professor Abugu. He says, with the digital and city innovations, the professional ethical rules that prohibit advertising by legal practitioners need to be revisited. A law firm having a website is now a given. This should be part of the catching up that needs to be done. I think any member of the panel can say something.
Mr. Olanrewaju?
Yes.
Mr. Olanrewaju?
Yes, Malam Yusuf Ali, Senior Advocate of Nigeria.
To back up part of what Edezogu said, the rules about advertisement is seriously relaxed now, even in the UK. That's where we borrowed the profession from, the way we practice it. So it's not the same like our own rules. Remember, our own rules have been in existence for only God knows how long, for decades. Their own rules keep on evolving as there are new opportunities and new challenges. Our own laws usually and rules do not meet immediate challenges. They are always very archaic. That was why it took us the better part of